The primary federal regulation governing employee layoffs is the Worker Adjustment and Retraining Notification (WARN) Act. Enacted in 1988, the WARN Act requires certain employers to provide advance notice of mass layoffs or plant closures, typically affecting 50 or more employees. Under the WARN Act, covered employers must provide affected employees with at least 60 days advance notice of the layoff, allowing them time to prepare for the transition and seek alternative employment opportunities. State regulations. In addition to federal regulations, many states have their own laws governing employee layoffs and termination practices. These state regulations may impose additional requirements or protections for employees beyond those provided by federal law. For example, some states have mini-WARN acts that apply to smaller employers or provide greater protections for employees in terms of notice periods or severance pay. Personal actions for employees. Review employment contracts. Employees should review their employment contracts and any relevant company policies to understand their rights and entitlements in the event of a layoff. Employment contracts may include provisions related to severance pay, notice periods, or conditions for termination. Seek legal advice. Employees should consider consulting with an employment lawyer to discuss their situation and explore their legal options. An experienced lawyer can provide guidance on relevant federal and state laws, assess the strength of the employee's case, and help determine the most appropriate course of action. File wrongful termination claims. Employees who believe they were terminated unlawfully or in violation of their employment contract may choose to file wrongful termination claims against their employer. Wrongful termination claims typically allege violations of federal or state anti-discrimination laws, breach of contract, or retaliation for exercising protected rights. Pursue discrimination claims. If an employee believes they were targeted for layoff based on protected characteristics such as race, gender, age, disability, or religion, they may have grounds to file discrimination claims against their employer. Discrimination claims are typically filed with the Equal Employment Opportunity Commission, EEOC, or equivalent state agency. Negotiate severance agreements. Employees may have the opportunity to negotiate severance agreements with their employer as part of the layoff process. Severance agreements may include provisions related to severance pay, continuation of benefits, non-disclosure agreements, and release of claims. Procedural taxes, also known as court fees or filing fees, are typically not exempt for employees when pursuing legal actions related to work layoffs in the USA. These fees are associated with initiating legal proceedings in court and are typically the responsibility of the party bringing the lawsuit, which may be the employee in cases of wrongful termination or discrimination claims. While some legal assistance programs or pro bono services may provide assistance to individuals who cannot afford court fees, employees should generally expect to cover these expenses when pursuing legal action. Additionally, employees should consult with their legal counsel to understand the potential costs involved in filing a lawsuit and explore any available options for fee waivers or financial assistance.